Hi, I'm Greg McIntyre, the elder law guy, here with a special guest, our attorney, Jane Dearwester,
Hi there. Glad to be here.
who is a fireball of estate planning and elder law information, as well as does a great job with litigation. Our topic today is how to protect your spouse if you have to go in a nursing home. So for me, Jane, it's if I have to go into an assisted living or nursing home facility, and I want to make sure that I don't suck up all the assets. I don't spend down all the assets and leave Steph, my wife, destitute.
Right. This is a major concern that we get. Clients are always asking about this when we're out speaking in the community, when we're out giving seminars in the community. This is probably one of the top 3 questions I get from people all the time. They want to know what happens. How can I protect everything? And then I also get people who argue with me and say, you have to sell everything you have. It's the only option. So
no. If you want to relegate yourself to be a ship with an engine and no rudder and just get bounced around by the waves of life, okay, and this situation that's going to come upon 70% of people over 65. 70% of people over 65 are going to need some type of long-term care during their life, either in-home assisted living or nursing home care, and it ain't cheap. We're talking average $10,000 to $15,000 a month, but you can spend down even a large estate. And then you're looking at, do I need to sell the house? And if you don't sell the house, they're going to attach a claim to your estate and force to sell the house if you pass away. Not good for spouses and not good for children and not good for you. So really, I like to work with spouses, Jane, on protecting the assets together. But also, what if just one needs to go into care? How do we make sure that the healthy spouse, let's say Steph, who is going to have a ton of healthy years to live when I wear my body out, okay? And I need help. And us men check out first anyway.
Usually.
It'll be like a vacation to me. It'll be the first vacation I've had in years. But I do want to make sure that she's taken care of.
Of course.
And it could be a wife making sure a husband's taken care of.
Yep.
And ideally, we'd be looking at this together.
Yes.
But let's talk about ways. I always start with the fundamentals. General durable power of attorney. The most important linchpin.
Yes.
The linchpin is that one thing you pull and the entire machine falls apart.
That's right.
Or it can hold everything together.
Yes.
That really pivotal linchpin thing is the general durable power of attorney.
Important. I'm always preaching this, that to come in and just have us do a power of attorney for someone is so quick, easy, relatively inexpensive. And if you don't have it in place, your other option is legal guardianship, which is a lot of court oversight, exponentially more expensive.
A lot more money for the attorney. So why aren't I preaching? Don't do it right now, because I want to make sure you have it in place. Okay. You don't understand how easy it is.
So easy.
But also don't understand how complex it is.
The
attorney drafts is like 23 pages long. And there's a reason, because if it doesn't say it in the document, you don't give that power. And I want to give Steph 100% power to do what I can do.
Yeah, one of the most important things that's in our powers of attorney and others is that gifting provision, that you allow your spouse to gift even to themselves if your spouse is your agent. Even
maybe transfer assets under the rules, and there's special ways to do that. But when you sit down with me or Jane, the question I'm going to have for really the grieving wife, the crying wife, two out of 3 times that's who it is, that's upset because she just figured out that they're going to lose everything to pay for their husband's long-term care stay.
Yeah, everything. That's tough.
And it's okay. Well, did your husband, was he thoughtful enough, smart enough to go see Greg and Jane and put in place a general durable power of attorney ahead of time? If not, we're talking about guardianships. And then we're under the watchful eye of the court, and we're begging the court, we're petitioning the court to do what we want to do. And the court doesn't always agree. And it takes a lot longer. It's more expensive.
And it gives the opportunity for other family members to come in and contest and who's going to be the best guardian. And you could end up with a third party attorney, basically a stranger.
Speaking attorney that's over your assets and your health care, maybe.
Yeah.
Right. I don't want to do that job, and nobody wants me to. So pick the person that's right for you. Okay.
Yep.
But Jane, we're married. I can do everything for my spouse. What are these guys talking about?
Yeah, that's a huge, common, very, very common misconception. Married couples think they do not need to have a power of attorney because they make an assumption that, well, we're married. That means we can do anything for each other. And I'm always correcting people. No, that's not what that means. Even spouses have to have the power of attorney in place.
Bruh. If I become incompetent, Steph is stuck.
Right.
Stuck. I mean, she can't move any real estate. She can't do any protective deed work if she hasn't done that. She can't put a ladybird deed on the house because I got to sign it.
Right.
She can't refi it. She can't sell it.
Can't take out a HELOC.
She can't take out a loan.
Nope.
She's stuck with any real estate we own. Individual retirement accounts. By definition, by the name, it's in the name. Individual. Oh, but I'm the beneficiary. That's cool. I ain't dead yet. You're only a beneficiary, and that only comes into being when somebody dies. So all these responses and these weird things we tell ourselves, we need to snap to reality, which is just because you're married in the eyes of the Lord and the eyes of the state doesn't mean that you have access to your spouse's assets, because you don't, unless your spouse is giving you access through that special document that's well written and comprehensive, a general durable power of attorney. And I'm telling you, 9 times out of 10, Jane, an attorney and an individual, when they're trying to look at the options and draft the general durable power of attorney, are going to nix and say, no way my agent should be able to gift to themselves. Horrible idea in a marriage, especially where between spouses, when there's potential long-term care issues in the future. That way you want to be able to transfer freely assets and do whatever we need to do to qualify for a benefit for the person who needs care. If I think I might need care and I really want to protect myself, my spouse, and my assets, I'm going to put that in place first. And then I'm going to move to the healthcare power of attorney, which I would say would be equally important because people get stuck there. That's required in a benefits application. Hey, that's one of the first things they're going to ask is, where's the healthcare power of attorney? So we need those foundational work in place, general durable power of attorney, healthcare power of attorney. And then let's talk about asset preservation and setup of assets. We get our foundations in place. I'm looking at in a consult for estate planning. Okay. Is there a primary residence? Or is there other real estate? How long are the funds? What are the total assets? Retirement plus private brokerage accounts plus savings, checking, CDs, money market, whole life insurance. What are the assets? Is their money stacked high enough that they can take a hit to really self-fund and self-insure for a long-term care stay, or is it really in danger of being spent down? And I'm looking at the makeup of the assets, the money versus the real estate, to tell me whether a ladybird deed is right for the home, or we're looking at going into trust, and whether we need, or some clients will want to instantly protect the home with a ladybird deed because it's not affected by the look back period. And we'll talk about what that is. And the rest, we use a trust to do it. And we use a special type of trust, irrevocable trust, because a revocable living trust, no help in long-term care planning at all. I see attorneys and individuals who've done long-term care planning, and they're sitting there with these revocable living trusts. And attorney, I already got this all set up. It's a revocable living trust, and I'm the trustee. Because you have your hand in that cookie jar, you keep your power of appointment legally. That's the key thing. You can revoke it, amend it. You made it, you control it, you're the trustee. You are totally that hand in the cookie jar. They consider it your assets still, and collectible assets, right? The same as in probate. So, Jane, a ladybird deed. Let's say my house is my primary asset, I need to get my powers of attorney and foundational work in place. How would a ladybird deed help protect me, my spouse, and pass my asset and free me up for benefits?
Yeah, I love the ladybird deeds, as you know, and others know. My background's in real estate. I did that for about 15 years before I transitioned into elder law, and never heard of ladybird deeds, never really dealt with them because it's not really a real estate attorney advice, really. It's an estate planning advice.
Just like selling a house. It's like,
right. Estate planning or real estate attorneys don't mess around with ladybird deeds, but I love how easy and powerful the ladybird deed is, because it's you decide who you want to leave your property to after you pass. You sign the deed now, but during your lifetime, you maintain all power and control over your property. You can do anything with it, including selling it. You don't have to get the ultimate beneficiaries or grantees to sign off on anything. But upon your death, it immediately passes to those named individuals outside of probate. Doesn't affect your long-term care qualification. Medicaid can't come back and try to levy against it. So it is such an incredibly powerful document.
I like to also call it the genius deed, because the most genius things are elegant and effective in their simplicity. And that's what it is. Look back period, doesn't matter. The benefits allow it in North Carolina to put a ladybird deed on today and apply for the benefit tomorrow. It's okay.
And it's important, again, going back to the powers of attorney, to have that gifting provision, that if you haven't had the ladybird deed in place and your spouse has maybe already crossed over that line of competency and you have the gifting provision, you can do the ladybird deed then. You don't.
Yeah. If I'm a child of someone needing care and I want to protect my spouse, maybe my children too, and I'm a child acting to put in place this ladybird deed because mommy and daddy didn't do it and didn't think about doing it.
Right.
It's the first thing I'm looking for to make sure, because they're going to ultimately receive that home, which could be considered a gift. It's arguable in the court, and I've argued it, but could be considered a gift. Okay. So, but other thing, trust. Let's talk about the trust, Jane.
Yeah.
Let's talk about, I want to create a container that can hold ownership to all my liquid assets, and I'm going to put some real estate in there too. The Medicaid Asset Protection Trust. Let's talk about that specialized irrevocable trust. How does it help me protect myself and my spouse should I need care?
It just gives that arm's length separation so that those assets, whatever you put in there, are not countable for the spouse who needs care, right? That's what we're trying to do. But I think where people show resistance is they don't want to let go of that control. They want to have their hand in the cookie jar. They don't want to take it out. They're like, I like cookies. I like having my hand here. But it's truly in their best interest to create that separation, that legal separation.
By gaining protection, I'm relinquishing control,
right,
to maybe a trusted child.
Yeah.
As my trustee. But don't they have a legal fiduciary duty to preserve those assets for my use and benefit for the rest of my life, Jane?
Oh, absolutely. Yes.
And also, aren't I still the lifetime income beneficiary? So that if I've got rental properties in that trust, if I've got investments, I still get the dividends, interest, and rents. I still get the income during my life. So I still just get all the benefits, right?
Right. I think that's
consider my asset.
I think once people understand how it works, it softens the idea of letting go of control. But I think initially people can have some resistance, especially people of a certain era, right, that are heading toward, their latter years. They can say, I don't want to let go of this. I've worked my whole life for this. And
there's a saying, the more you try to maintain control of something, the more it controls you.
Ah, that's a good one.
So the tighter we hold on, really, control is an illusion anyway.
That's true.
So what we can do is set it up so you get all the benefits but not the detriments when it comes to obtaining a benefit to pay for long-term care. So you get the benefits as the lifetime income beneficiary, and you get the benefit of the long-term care benefit. Okay. Yeah. So that's just a win-win. And those are really great tools for many people, especially as we age, to really shift to a more protective, contemplative, prepared role. Okay. Yep. And I love the Medicaid Asset Protection Trust and the power it has. But alas, best laid plans, I do my work, got to change title to the assets to the trust.
Yes, don't forget that's an important step.
Fund the trust. Fund the trust. Yes. And that's so important that we get it out of your personal name, titled in the name of the trust. Accounts, real estate, we'll draft the deeds to transfer the title into the trust.
And for the assets we can't put in the trust directly, we need to change those beneficiary designations on other qualified accounts to name the trust as the beneficiary. Also, your life insurance, name the trust as the beneficiary. So everything's being funneled into.
Or another discussion I always have with clients, Jane, is so life insurance has 3 positions within it. There's the owner of the policy. There's the insured, whose life is tied to the policy, which doesn't have to be the individual that's the owner. I can take out a life insurance policy on you, Jane, if I want to. And there's the beneficiary. Yep. So 3 positions. Okay. The trust can be the owner. And in many times we want to contemplate the trust being the owner, especially with whole life policies that have value. You're still the insured, and the beneficiary, when a life insurance product is in a trust, the beneficiary becomes the trust beneficiaries, and we can reference that specific product and who's the beneficiary in the trust. So that is a really cool thing to do, because the benefits rules limit how much life insurance you can have and the value of it to qualify for the benefit. So we want to be contemplative. I look at, Jane, a Medicaid Asset Protection Trust is the best safe I can build for you in North Carolina. And we close that door. The only outlet is this hole for income that's coming out to you. And if you need care, there's alternate lifetime income beneficiaries where that flow of income can switch to the alternates, which might be loved ones, it might be children. So it's not counted as your income to be paid toward a facility and what's called patient monthly liability in the benefit. So it's just your Social Security, pension, non-divertible income. Yeah. So we want to preserve the income and the assets, and life insurance many times is an asset, and we need to pay attention to the value of the life insurance and whether we want that to be owned by the trust. Annuities are life insurance products. Life insurance companies created annuities. Those are life insurance products. The trust can be the owner. You can still be the payee off an annuity paying out, right? And you're the lifetime income beneficiary of the trust. So we really want to understand what these different assets are and how how you can put them in the safe. Okay. Yeah. So anyway, Jane, this has been a great discussion, and I appreciate you having it with me today.
There's so much to know, right? There's so much to know.
I think we hit some high points. There's so much nuance as well, and additional things that we could talk about all day.
Yeah.
That's why it's important to sit down with a competent, knowledgeable estate planning and elder law attorney to discuss these things to protect yourself, your spouse, and your family, your children and grandchildren.
Yeah.
So, what we do, Jane, I know Jane would be happy to do it, is we offer a free consultation to sit down and discuss these matters. And you can take advantage of that by calling one of our office numbers. Hey, we have one number that'll ring all of them. So just call and get us. It's 1-888-999-6600, or you can schedule directly on our calendars. We open ourselves up. We're very free and open at our firm. We open our calendars up to everyone. Go to mcelderlaw.com/scheduling, and you can schedule directly on mine, Jane's, or one of our other attorneys' calendars. And Jane, thank you very much. I appreciate you being here with me today and discussing this great topic.
Yeah.
You have a great day, Jane.
You too. Thanks.
All right.